Imagine facing criminal charges, but the legal labyrinth isn't just in one state, it's across several, with warrants, bonds, and conflicting court dates. That's the complex reality for Nathaniel Jackson in today's intense courtroom showdown.
All rise.
Here in the state of Ohio versus Nathaniel Jackson, case number 25 CR 1652. The defendant is present with counsel Paul Meyer. A 2-count indictment was filed in this case on December 3rd, 2025. Count 1 is failure to comply with an order or signal of a police officer, a felony of the 3rd degree, and violation of Revised Code Section 2921.331B. Count 2 is misdemeanor theft, a misdemeanor of the 1st degree, and violation of Revised Code Section 2913.02A1. The state has offered for the defendant to plead guilty to count 1, and the state would dismiss count 2 at the time of sentencing, and there is no agreement as to sentencing.
All right, Mr. Meyer.
Here we see the initial plea offer presented by the state. Mr. Jackson is facing a 3rd-degree felony for failure to comply with an order or signal of a police officer, which in Ohio, under Ohio Revised Code, typically involves fleeing or eluding a police officer and can carry significant prison time. The second charge is misdemeanor theft, a 1st-degree misdemeanor under Ohio Revised Code. The prosecutor is offering to dismiss the misdemeanor if Jackson pleads guilty to the felony. This is a common plea bargaining strategy. The state gets a conviction on the more serious charge without the expense and risk of a trial, and the defendant potentially avoids a second conviction on their record. The crucial part, however, is no agreement as to sentencing. This means if Mr. Jackson accepts the plea, the judge retains full discretion over his sentence, which can be a calculated risk for the defendant, as the outcome is not guaranteed.
Thank you very much. May it please the court. Was Mr. Jackson previously arraigned on these charges?
Yeah.
Yes.
He was, sorry. As the court knows, I just recently filed a notice of appearance and a request for discovery in this matter. The prosecutor has indicated that she's going to furnish the discovery to me in the very near future. So I do want to review all that. And what I'd like to do, with permission of the court and the agreement of the prosecutor, is to continue this pretrial to a second pretrial on March 18th, I believe. We had a time for 2:30 in the afternoon.
Right.
And by then I'll have a chance to work on Mr. Jackson's other cases, take a look at the evidence in this case, and try to see if we can get it resolved. Thank you.
All right. Mr. Jackson, do you understand what the offer is in this case?
Yes, Your Honor.
All right, I'm going to set this case for a jury trial March 30 at 8 a.m. We'll have another hearing that'll be March 18th at 2:30. If you're going to accept that offer, that will be the date and time at which that occurs. You understand that?
Yes, sir.
All right. Anything else, Ms. Gold?
Nothing from the state, Your Honor.
Mr. Meyer, anything further?
Yes, one other matter. I know the court imposed a warrant on Mr. Jackson in this case, and he wanted to explain to the court why it was that he was unable to be here when the last session was held.
Yes, good morning, Your Honor.
Morning.
I missed court last time because I was going to come, but I missed court because I was incarcerated in Cuyahoga County Jail. And I talked to the lawyer that I had on this case, but he recused himself. And he told me that he could get like a continuance, and he never got the continuance. He just recused himself. He took himself off the case.
This segment highlights a critical issue, Mr. Jackson's prior attorney's actions. When an attorney recuses himself or takes himself off the case, it means they've formally withdrawn from representation, often due to a conflict of interest or inability to continue. This can lead a defendant in a precarious position, especially if, as Mr. Jackson alleges, promises of a continuance were not kept. Missing a court date, even if incarcerated in another jurisdiction, will almost always result in a bench warrant being issued by the court. While Mr. Jackson states he sent a motion of availability, the court's system for coordinating across different states and correctional facilities isn't always seamless, leading to situations like this where a defendant believes they were communicated, but the warrant remains active, complicating their release.
And that's why I had got a warrant for that. And I was in jail, but I sent a motion of availability here.
Okay.
And I still got the warrant. So I'm just trying to get like the warrant, because I paid a bond. I paid
Right.
my bond.
And your bond's still there. Okay, it's not been forfeited. It's still there, but,
It says it was revoked.
well, it was revoked. which means, but if I reinstate it at some point, it'll be the same thing. It's still there, okay, until this case is concluded. So if I don't, I'm not gonna reinstate your bond today. We're gonna send you back to Cuyahoga. That was our deal with Cuyahoga. You gotta go back there, try to resolve these things, and maybe we can get it all done. But if this case resolves before you're out on bond, you're gonna get that, whoever posted that bond is gonna get that back.
Okay, so I don't have a warrant? for
Well, you don't have a warrant right now because you're here
Okay.
on that charge, okay?
Okay.
But I talked to Mr. Meyer about this before we came out, and was going to try to see if these other things can be resolved before you come back here in March.
Okay.
All right?
So when I go back to Cuyahoga, I won't have the warrant for you guys anymore?
You don't have a warrant, but you have a holder, okay, because you're eventually going to come back here, okay?
We're not finished in Lake County.
Right.
So when you go to Cuyahoga County, there will be a hold on you to,
So I
so
have to
they
come
know-
back here?
Yeah, you
Yes.
got to come back here. We got to resolve this case one way or another. So you'll be back here in March 18th.
So I can't go home from Cuyahoga?
Well, I don't know what your status is.
They gave me GPS monitoring in Cuyahoga County. So
Okay.
once I go back.
Well, here, then here, let me suggest this to you and to Mr. Meyer. If you've got a bond in Cuyahoga, and then I understand you got to go to Summit also?
not in Summit. Your Honor, if I may,
Yeah.
can explain this a little bit. I'm not handling the Cuyahoga County case for Mr. Jackson, but
All
I
right.
spoke to his attorney in that case yesterday. The judge in that case reinstated his bond in Cuyahoga County and sentenced him to
Home detention.
put him to home detention with GPS monitoring.
Uh-huh.
So he will be allowed, when he gets his bracelet on, to leave the Cuyahoga County Jail and go home
Okay.
to
And
his
I will
residence.
be able to, I have permission from my judge and my PO to go to my other court dates, because they know about these cases, to go to these cases, like to come to court for these
Okay.
cases.
Then what I would like you to do, Mr. Meyer, is file a motion to reinstate the bond. Give me the information
I will do
of
that.
what's going on in Lorraine, what's going on in Cuyahoga. And then if what Mr. Jackson says is true, then I will likely give him kind of the same terms as Cuyahoga.
Here, the judge is exercising judicial discretion, indicating a willingness to work with the defense, but requiring proper legal procedure. The term holder the judge uses refers to a request from one jurisdiction to a correctional facility in another, asking them to detain an individual until the first jurisdiction can take custody. It's not a new warrant, but an instruction to maintain custody. Mr. Meyer's strategy to file a motion to reinstate bond is a crucial procedural step. Under Ohio Criminal Rule 46, a court can set conditions for release, including bond. By demonstrating that Mr. Jackson is already on GPS monitoring and home detention in Cuyahoga County, his attorney is arguing that he is not a flight risk and poses no danger to the community. The judge's willingness to likely give him kind of the same terms as Cuyahoga shows that the court is open to considering release conditions that align across different jurisdictions, provided the defense provides verifiable information. This proactive legal work by Mr. Meyer is essential to getting his client out of jail and back to some form of supervised release.
But let's see it.
Okay.
Let's see it add in the motion, okay?
So, Your Honor,
All right?
so when I'm released.
All right.
Do you want to say anything else?
Go ahead.
So when I'm released from Cuyahoga today, because they're gonna give me my bracelet when I go back today, I won't be able to go home. I have to come back.
Not until I rule on your motion to reinstate the bond.
I'm going to file a motion for the judge to consider to reinstate your bond here based on what's happening in Cuyahoga and other jurisdictions.
This dramatic courtroom exchange showcases the real-world complexities of the justice system, especially when defendants have cases spanning multiple counties or even states. As for Nathaniel Jackson's specific case, without further public updates on this specific case, it's presumed to have proceeded through the legal process beyond this pretrial hearing, but the specific verdict or sentencing is not yet publicly reported. This often happens with cases that don't reach a high-profile status, emphasizing the quiet, grinding work that goes on in courtrooms every day. Public records regarding its final resolution are not readily available at this time. The case was in its early pretrial stages as of this transcript, with dates set for March 18th and March 30th, 26. However, a Lake County, Ohio booking record from February for Nathaniel Earl Jackson does indicate his presence in the system around the time of these proceedings.